How can you avoid Texas Medicaid Estate Recovery? If you or a loved one is considering Medicaid in Texas, you might be wondering how to avoid Texas Medicaid Estate Recovery. This process can impact your estate after you pass away, so understanding it is essential. Texas Medicaid Estate Recovery seeks repayment for certain long-term care costs from the estate of someone who received Medicaid benefits. Knowing how to navigate this can save your loved ones from losing assets. First, let's talk about what the state targets. Texas Medicaid Estate Recovery usually focuses on assets that go through probate. These are properties owned solely by the deceased without a named beneficiary or joint owner. Common examples include homes, cash, and other assets that do not automatically transfer to someone else upon death. One effective strategy is to name beneficiaries on your accounts and policies. When you designate a beneficiary for life insurance, bank accounts, or investment accounts, these assets can avoid probate. This means Texas Medicaid Estate Recovery cannot claim them since they pass directly to the named beneficiary. Another option is joint ownership with the right of survivorship. If you own property jointly with someone else, it automatically goes to the surviving owner outside of probate. This can help protect the asset from estate recovery, but it is important to plan carefully to avoid any unintended issues. Using trusts is another way to shield assets. Certain types of trusts can protect your property from probate and Medicaid estate recovery. For instance, a properly structured irrevocable trust may remove assets from the probate estate, making them unavailable for recovery. Timing is essential here. Transfers should occur before applying for Medicaid to be effective. You might also consider gifting and asset transfers. Transferring assets before applying for Medicaid can reduce the size of the probate estate. However, be cautious. Medicaid has look-back periods for these transfers, and improper gifting can lead to penalties or disqualification from benefits. Texas law does provide some exemptions. If the estate is below a certain value, or if recovering assets would cause undue hardship to survivors, such as a spouse or a disabled child, exemptions may apply. Finally, having the right estate planning documents is vital. Wills, trusts, and other planning tools can guide assets away from probate and to intended beneficiaries. It is wise to consult with an attorney who specializes in elder law and Medicaid planning to ensure everything is set up correctly. For families concerned about Texas Medicaid estate recovery, early planning is key. Regularly reviewing beneficiary designations, considering joint ownership, and exploring trust options can help protect your assets. Staying informed about changes in Medicaid rules is also important. Consulting with a legal professional can provide guidance tailored to your situation. By using these strategies, you can help ensure that more of your assets are preserved for your loved ones rather than being subject to Texas Medicaid estate recovery.